Did you know that your landlord is legally required to make repairs to your home? My name is Henry Mantel. I'm a tenants' rights attorney and a candidate for LA City Council, and I want to tell you about one of my favorite laws, the Implied Warranty of Habitability. The Implied Warranty of Habitability basically states that any landlord who wants to rent out a residential property to human beings has to ensure that that property is fit for human habitation. And this warranty is implied, which means that it applies to every residential tenancy in the state. So the kinds of things landlords are obligated to fix include, but are not limited to, water leaks, broken locks, defective plumbing, cockroach, rat, or mold infestations, unclean common areas, and basically anything that impacts tenant health or safety. Now, there may be exceptions to this rule if a landlord can show that a tenant caused these problems, but generally they are legally required to fix these things as long as they have notice of them. So if you're a tenant with a defective condition in your home, here are some steps I always recommend tenants take. First, document the problem by getting photos and videos of it. Second, notify the landlord immediately and do it in writing. Third, you need to give the landlord a reasonable period of time to fix the problem. Now, what a reasonable period of time is can change depending on the circumstances, but generally reasonable is considered to be at least 30 days. And if the landlord fixes the problem within a reasonable period of time after getting notice of it, great, the landlord did their job, everyone's happy. Now, if the landlord doesn't fix the problem within a reasonable period of time, tenants have some options. First, a tenant is legally entitled to withhold their rent if a landlord is refusing to fix defective conditions in the home. This is an option I usually recommend saving until later because even though a tenant may have the legal right to withhold their rent, a landlord can still potentially go forward with an eviction for not paying your rent. Now, a breach of the implied warranty of habitability is a legal defense to a non-payment eviction. However, if you can avoid having to go through the eviction process at all, I would typically recommend other options first. The second option tenants have is called repair and deduct. A tenant can repair the problem themselves and deduct the cost of repairing the problem from the rent, only if the cost of repairs is less than 1 month's rent. Third, you can complain to a government agency. In Los Angeles, it's usually either the Los Angeles Housing Department or the LA County Department of Public Health. Fourth option for tenants is just moving out. There's something called a constructive eviction, which basically says that if a landlord is not fixing defective conditions, then they are not upholding their side of the lease and a tenant is within their rights to break the lease and just move out. Fifth option is you can file a lawsuit. This was actually my job for the last year and a half. I was suing landlords on behalf of tenants for breaching the implied warranty of habitability. Now, suing your landlord for these issues may not actually get the problem fixed, but you may be able to get some compensation for the damages that these defective conditions have done. So that was a quick course on the implied warranty of habitability. I really hope this was helpful.